That's good. That's good. Well, it'll be interesting conversation as we get started. So
Yeah.
that's funny. So we'll let some folks get entered in here. I know I reached out for a couple broker owners and said, hey, you know, this might be something you want to check out. So let everybody open that up in the meantime, and then give them a couple minutes, and then we'll get started, gentlemen. So
All right.
Good deal. Good deal. All right, good. We got a couple people coming in. It's good. It's about 12 o'clock. So we've got an interesting topic, and I'm going to go into a little bit on the topic and a little background how we landed here, and then we're going to give you guys a couple some bios on the folks that'll be speaking for us today, and then let you guys know how you'll be communicating with us essentially through the chat for any questions that you have. So to begin, who we have is we have Charlie Franklin and Craig. Oh, I don't know, Craig, we never cleared this. Is it Capilla?
It's Capilla, yeah. Good
Capilla.
Good run at it. There you go.
All right, there you go. So two lawyers, which are part of Franklin, Greenswag, Channon, and Capilla, LLC. And they have a very unique position in the sense that they help represent people people who are licensed by the IDFPR. And those can include real estate agents, mortgage loan officers, even your hairdresser gets the license by the same place that we get our license. So if in fact the IDFPR ever were to call you about your license and ask you questions, you may want to take along one of these gentlemen, and I'm sure they'll expand on that, why that's important. So a little background on Charlie. Charlie's managing partner of Franklin, Greenswag, Channon, and Capilla. And since 1980, Charlie's practice has been focused on representing professional real estate appraisers and licensed property inspectors in malpractice claims, lawsuits, and disciplinary hearings. Charlie also counsels clients and companies and policy holders in insurance coverage disputes, presentations of claims, and recovery. He has successfully argued before the Illinois Supreme Court on a case involving exculpatory provisions and limitations of liability. Charlie also often serves as a neutral or independent arbitrator appointed by insureds and insurers. For several years, he has been elected a Illinois super lawyer. What is that, Charlie?
It's a rating. They have a lot of these rating services that are put out by peers and things, and they elect you to be a super lawyer. I don't know what that means. Don't tell my kids, or my kids don't believe it, but my wife doesn't believe it. But
there you go. It's a peer-reviewed and rated AV preeminent with Martindale and Hubble. Charlie was a founder and original board member of the Claims Association of Greater Chicago. And Charlie, I consider a friend. Charlie and I have known each other for 6 years, maybe, Charlie?
At least, yeah.
It's about 6 years. So Charlie's been a great resource for me, certainly, if I have questions. Craig is one of their partners there. He's a trial lawyer concentrating his practice on a wide range of civil litigation, including professional liability and commercial claims. As a former IDFPR prosecutor, that's right, guys, he was on the other side, which I'm told is how these two met. Craig has also represented numerous licensed professionals in Illinois and Wisconsin on licensing matters, including real estate brokers, real estate appraisers, medical doctors, process servers, mortgage loan originators, and brokers. He has represented clients in both state and federal lawsuits and has appeared in various judicial circuits across Illinois and Wisconsin. He has also assisted professionals with licensing proceedings and regulatory investigations in Iowa, Minnesota, Michigan, Colorado, Idaho, Delaware, Maryland, Nevada, Louisiana, and Missouri. So thank you guys for being here. We're going to turn this over to the gentlemen who have a PowerPoint to go through. I'm going to reach back out to you guys and just let you know if you're going to communicate, there is a chat box. You can hit the chat box with any of your questions, but we'll let the gentleman take over for the PowerPoint, and I'm just going to moderate from here.
Excellent. I'm going to go ahead and tee up that PowerPoint. Thanks, everyone, for joining us today. I'm going to get that all set up here, and then we'll let Charlie actually kick us off as we get into it. Let's make sure. All right, I think we're
You got it
on the
there?
screen share,
All right.
and let me go to the slideshow setting, and we should be all there. We go.
All right, thank you. First, I wanted to thank Rich and Tony for setting this up. Craig and I have looked forward to this, to get before you and talk to you about the issues that, at least that we see and things. Rich alluded to the IDFPR and all that it regulates. There are over 400 professions in Illinois where you need a license, and they run the gamut, like he was saying, from brokers, real estate brokers, and real estate appraisers, and real estate inspectors, and then physicians and even attorneys who at least are regulated, to hairstylists. And in fact, we're involved in a case right now with a hair braider whose business was shut down because she didn't have a license to braid hair. So when you think about people who make, French braids or anything, do the kids, if you pay for it, you're going to need to have a license for it, because the state is regulating these things and is looking at that as a revenue source. All right, well, so let's get started. As I was preparing today for this session, I was one of a refrain from an Eagles song or a Don Henley song. The Heart of the Matter came to me, and I was thinking, there was part of that song, and forgive me if I don't get all the lyrics right, but it says, I got a call today I didn't want to hear, and then it ends with forgiveness. It's all about forgiveness, and that basically is what you do with the IDFPR. The IDFPR, as a government entity, is interested in accountability and compliance. They don't really care about your financial success. That may be ancillary to it. They may be fine, but they're there to make sure that you basically complied with the law and followed whatever it is, those minimum steps. There's a mantra when people are investigated and looked at that we try to follow in our office, and it's served, I think, almost all of our clients in good stead. It's not something that we don't have a perfect record. We've had cases where people have lost their licenses, but by and large, it holds true pretty well, and it's something that we'll cover over and over again in this session today. And it's what I call the 3 C's: candor, contrition, and cooperation. There are a lot of corollaries for those, but it's those 3 things that I think you should keep in mind if you ever have the unfortunate situation where you are confronted by a regulator. It goes across the board. It's just not IDFPR regulators. It's basically any kind of licensing body or certifying body where discipline is at the heart of it. It's all important when it comes to the IDFPR because you're dealing with a bureaucracy, and so it has an impact. The IDFPR looks at anyone with a license as a professional. You are a professional, and your worth lies in the opinions in your subjective analysis, basically, and skill. It's assumed as a professional, and they assume as you being a professional that you use due diligence and care, and that you're doing reliable work. Practicing, though, they also understand, does not require perfection. And that's something you have to keep in mind. Mistakes happen, and they acknowledge and recognize mistakes happen. It's whether or not you have a rational basis for what you did, or the service you provided, or the recommendation that you made, or the comments you gave. There has to be a rational basis. It can be wrong, and they understand that. And that's something you as a professional sort of have to also understand. When we represent, Craig and I have represented all kinds of professionals. I don't want to disparage doctors, but doctors have the hardest time admitting they made a mistake. And it's okay when you're dealing with the IDFPR, at least, to admit that you made a mistake. It's recovering from that mistake. It's finding out why it was a mistake that they're interested in, and whether or not you had a good reason for it. Expediency is a lot of times why people do things. That's not a good excuse necessarily. It may be in the moment, but we're all we're all in a service industry, you being brokers, us being attorneys. And so it's just something to be aware of. So what is a license? A professional license is permission. It's like a driver's license, if you think about it. A driver's license, to get a driver's license, you got to study. You have to pass a test. You have to demonstrate at least once some minimal competence to operate a car. A license and a driver's license is not a guarantee, though, that you'll be a good driver, or that you'll always, that you'll drive without accidents or anything like that. And it can be taken away even if you never get into an accident, or even if you don't hurt anybody. For instance, if you get too many tickets for speeding, you'll lose your license. You didn't hurt anybody, you didn't hit anybody, but your license is gone. And that's how the IDFPR looks at these things. If you, Craig, you want to go to the next page?
Yeah, the next one's actually one of my favorites.
The next one, this was in the Tribune actually about a year and a half ago. And it's apropos because, like I said, Craig and I represent a hair braider. This cartoon, I think, encapsulates what regulation does and what the IDFPR can do. And that simply by not following their rules, you can lose money, you can lose your livelihood, and you can lose your freedom. And so, there can be overlap for all three. You can have these private causes of action where somebody sues you because you did something wrong. You can have the state investigating you, meaning you're taking your license away, or because you did something wrong. And then finally, you can have a criminal prosecution because you did something wrong. And again, all three of them. If you don't have a license, you can't make a living. And so, there can be overlap, and they can be used concurrently by different parties, by the same parties or not. And you'll frequently see things where people will file a civil lawsuit, hope to get an advantage in that lawsuit by filing a complaint against your license, not against you, it's against your license at the IDFPR, and then possibly doing some other things. So you have to be careful and cognizant of what your exposure is. And it can be.
Charlie?
Yes, sir.
If I could ask, does the, as we study every year for our federal renewals, one of the things we have to study is, which federal agency, and even some of our state licensures, Florida and Wisconsin, for example, where we're licensed, which department can actually come after licensees for specific things. So where I was going with this was, does the IDPFR have enough of a hand to say, hey, I'm going to go after you licensee and you could serve time? Or is that something they have to turn over to another agency? Or
well, criminal prosecutions are done by usually, it depends, by the government, the U.S. government, which would be the U.S. Attorney's Office, or for state matters, the Illinois Attorney General or the state's attorney, depending on the crime that it is. Typically, the penalties that the IDFPR can do is strictly related to your license. Now, if you are prosecuted by the IDFPR, you'll frequently have, if it's, for instance, mortgage fraud. One of the problems that you had with mortgage fraud was that there was always an FBI agent in the back of the room when you'd have an administrative hearing. So if you testified as an appraiser or a broker and you were somehow involved in some sort of mortgage fraud situation, if you didn't take the fifth, they were going to use whatever you said against you. So you were stuck with this Hobson's choice necessarily, where, listen, if I testify, they're going to use something against me. If I don't testify, I'm going to lose my license. There is no Fifth Amendment privilege when it comes to having a license. So you have to be aware of it. And that's where an attorney comes in handy, because maybe you can negotiate something where you don't have to testify, and you can accept some sort of discipline where you have not admitted anything necessarily, so that the feds or whoever the prosecuting authority is can't use it against you. But it certainly does happen. And you can, again, you have concurrent prosecutions that you have to be cognizant of. And
That's a great, that's a great answer. I appreciate that.
Sure.
That makes more sense to me.
Something else that you also have to be aware of, if you have multiple licenses, a lot of times you have brokers who are also appraisers, or you'll have in multiple states. If you are prosecuted in one or under for one discipline, you have to report it in the other ones. And if you, for instance, if you're licensed in Illinois and Wisconsin, and if you're, up in Lake County or something, sometimes you may have a license for Wisconsin, Kenosha or wherever, or in Lake County, and you may do business in both places. Well, if you get investigated in Illinois, you have to report to Wisconsin that you're under investigation. And if you don't, that can be a problem. Wisconsin can say it. We've had situations where Wisconsin investigated somebody and let him go. He didn't report it in Illinois. Illinois prosecuted him for not telling them that he was being under investigation in Illinois, even though it had been dropped in Wisconsin. And then Wisconsin prosecuted again for being prosecuted in Illinois and basically pleading that, yeah, you're right, I made a mistake. So you have to really be careful. There's a lot of circular logic that's involved. So it's something to be aware of. And it can be, as you have to stay up to date as far as not every year, but every year with the Uniform Standards of Professional Appraisal Practice, USPAP. They have a new edition every couple of years that are put out. But there are other acts that are also done with brokers. There's the Real Estate Licensing Act of 2000. And there was a sunset for it. They've just now enacted some new amendments and provisions, particularly that deal with discrimination. Craig could talk more about what a lot of the changes are. But these are all things, if you don't, for instance, addresses, if you don't notify the state within 30 days of a change of address, that's a problem. Even though it may be totally innocent, innocuous, and nobody's hurt by it, it's a violation. Go ahead, Craig.
So one of the things that it's important for people to be aware of, and this is specific to the Real Estate License Act. So this will be for the managing brokers, the non-managing brokers, just regular old broker, leasing agents and the like, is there has been a rather significant update to this license law and the corresponding rules that go along with it. And those are two different aspects of the regulatory structure, which the first thing is there's a law that gets drafted, gets introduced down in the legislature in Springfield. If it passes both chambers, it goes to the governor's office, the governor signs it, and then it becomes a law. And that is usually the first step in the process. There's a whole separate backdrop to this, which are the administrative rules that sort of fill in the blanks and provide color to a very black and white dry law. Those are done without the legislative process and debate. Those are actually done somewhat internal to the agency, and those go through a completely separate process and run on their own separate clock. They don't require the governor's signature. They don't require a vote of the chambers, but that's really oftentimes where the meat on the bone really comes into the regulatory structure. So first you get a change in the license law, and there have been some changes. We're going to talk about a few of them here. And then you end up waiting to see what happens to the rules that are supposed to correspond with the law. For example, this license law we're talking about here, the update did occur actually well over a year ago. The first impact changes to these took effect in late 2019, in August of that year. Now, the problem came in that this was a transition period for the state of Illinois. And so even the state's real estate board, even the administrators at IDFPR didn't actually know what was going to be in the new license law until they got a copy of, hey, Springfield just passed this and it's going to the governor's desk now. Here's your new law, should be effective next Tuesday. Okay, that's not a great way to get prepped up for something that is a once a decade big swing at making formative changes. I bring that up to say that the corresponding rules that are supposed to go along with this are currently under review. We're 2 full years after this law has taken effect, and yet we don't have a fully operable set of rules to fill in the blanks and provide color. Why? Because the department develops the rules. Well, they didn't get the 1.5 to 2 years head start of redrafting the law They got a brand new copy of what was going to be the law, new and fresh, and had to start from scratch there. One of the things the department has done as a big push in all of this is one of the first items that we identify is addresses. And as Charlie mentioned, you have an ongoing obligation as a licensee to provide the department your current address. If you don't do so, that in itself is a violation because the department needs to know how to reach you and where to find you. More significantly than ever, though, it's important that you provide a good working email address, because as the department would have told you 7 or 8 years ago when they made this push, they've gone green. And in an effort to be more environmentally conscious, they are trying to get away from physical mailings of things. All right, having been a former department employee and former prosecutor over there, I can tell you the real inside baseball. The department actually, and the entire state, because we're broke, ran out of money to pay for postage. So don't let them fool you that this is some great environmental kick. The reality is they serve their legal documents now via email. You get a complaint against you, they're going to email you about it. They serve you with a legal complaint telling you to show up in court. It's coming to an email box. It's not coming certified mail like it used to because they're not paying for the postage of that. But there's a flip to that, and we'll get to it here in a moment. Regardless, you must provide them with an active and working email address, or you will miss all of the information that the department wants you to know about, and you won't be able to be contacted by them. And Charlie talked about his 3 C's of candor, contrition, and cooperation. I can tell you from the inside, the other side of that coin, we also had rules when I was at the department, and it was don't lie to us, don't ignore us, and don't poke the prosecutor with a stick. That doesn't roll off the tongue as easy as the 3 C's, but that was a part of it. The don't ignore us part was a really big deal over there. If you're not receiving communications from them because they don't know how to get a hold of you, you're going to have a real fast problem with the don't ignore component of all of that. There's another aspect to all of this, which is inactive licenses. If you look in the license law as it's currently written, inactive license simply means that at that moment in time, the licensee is not authorized to practice under that license. For real estate brokers, perhaps your card has been terminated by your sponsoring broker. You're looking for a new place to hang your shingle. During that period of time where you're unsponsored, you're inactive, or a fee didn't get paid properly, what a check bounced, or there's a whatever the case may be, you're not authorized to practice at that moment. If it's the entity itself, it's a branch office or something like that, if paperwork gets misfiled, if something doesn't go forward like it's supposed to, the license may turn to inactive. That's not actually a new component of this license law, but I bring it up to warn people that there is a change that's possibly coming here, and it would actually be a change to the benefit of the profession. A number of other professions, the doctors have had this for years. Most recently, as of this last fall, the appraisal bill got language put in there for an inactive status where the individual licensee can reach out to the department and say, hey, I'm going through a period of hardship here. I don't have the ability to renew my license at the moment. I'm having a medical problem. I'm having some other hardship. I would like to make my license inactive, and I'd like to pick it up again later and go down the road. Prior to this, for most of these license acts, and again, it's not unique to just real estate brokers, it was really all of the licenses. It was every 2 years you renew that license. And if you miss it, you have to pay a late fee, and you must renew in that next 2 years. If you didn't make that first renewal cycle, you had to go back and start from scratch, take all of the classes, all of the work hours, and start from the bottom and build up again. There has been a push within the department to recognize that that's not necessarily a good outcome for folks. Sometimes there's a legitimate reason that they cannot renew right away, and it's tentative. So slowly but surely, you're seeing that work in. I expect we're going to see language like that coming for the Real Estate License Act at some point, not too far down the road here. It has percolated into other acts as well. So I think we'll see something like that coming. So I want to call it to everyone's attention. The next item we have on the list here.
Greg, I'm going to
Go ahead,
interrupt
Rich.
1 second.
Yeah.
I just put just to remind everybody, questions you might have in the chat, check that out. I put a question out there for you guys. You know, just the one simple thing that you brought up before the last point, which is still excellent. I think that provision needs to be there to allow somebody to step away and come back. But ultimately, the bigger thing certainly is to make sure that everybody here, make sure the IDPFR has their correct email address, especially if you need one of these guys and you don't know it. So Craig, go ahead, your next point.
I'll tell you right now, if the one takeaway from all of this today is that everybody gets done with their Jimmy John sandwich that you sent them, logs off this thing, and then goes and checks and makes sure the department has a valid email address, that's a huge win in my book. That at least that will have covered over some areas that are very easy to slip through the cracks. So if that becomes the takeaway from today, I'm all in favor of that. A couple of other positive changes that we're looking at here. The next item we've got on this list is something called citations. In the past, when it was a renewal cycle and continuing education credits needed to be submitted, the department has vacillated a number of times on how they're handling continuing education problems. In some years past, it's been, oh, a quick slap on the wrist, do better. In other years, it's been an extremely large fine and a suspension of a license and all sorts of garbage in between. And it really depended on who was sitting in a particular chair at that point in time, which way the wind was blowing. Well, in order to try to eliminate some of that uncertainty into the Real Estate License Act and several of the other acts now, there is actually a section of the license law that deals with citations, which is to say, it's now like it's a speeding ticket. If you don't have your continuing education done, you still have to get the education done. But there is a fee schedule that you have to pay a late fee and a penalty for not getting it done. And you have to get it done by a certain point. But it's taken the uncertainty out of the process, where in a given year, someone might be told, pay a couple $100 and get it turned in by next Thursday. The next cycle, somebody else is occupying the post and they go, well, we're going to suspend you for 6 months and fine you $7,000. Yeah, that is outrageously variant. And so they've removed a bit of that here by inserting this idea of citations. Go ahead, Charlie.
Yeah, I was going to say, well, and one of the things that Craig just made a mention of, there's a difference between a fee and a fine. A fee, and when he said, you know, it's like a speeding ticket and you pay a fee. A fee is not considered discipline. A fine is. And so if you pay, you know, many times when you're dealing with them, and even these innocuous situations, they'll waive something, pay a $500 fine and everything goes away. The problem is, as a fine, it's a discipline, and as a discipline, it has to get reported to everybody. If you're on any kind of national registry, if you're, again, licensed in any other state, or you have a discipline, or you have a license that's not a real estate broker in Illinois, you have an appraiser license, you have to report it, you know, to the to Brian Weaver, to the appraisal authorities, you know.
Yeah, and Charlie, that's really important. I was actually talking to a broker owner yesterday, and he was telling me that they read those reports, and then if they have a new realtor come into their office who wants to be part of their group, hang their license there, that's one of their due diligence processes, to go see if that particular agent has ever incurred any sort of fine. And so, like you said, you don't want that there. The fee would be better than the fine for sure.
Right. And then it's, you know, the long-term impact as far as expunging. There is a process if it's, you know, related to you know, like you'll get dinged if you don't pay child support, or you don't pay taxes, or you don't do other things. Now there is a process on certain limited areas where you may be able to get it expunged after 3 years. But it's a hard thing, and it's something to be aware of. I'm sorry, Craig, I didn't mean to cut you off.
No, that's spot on. That's important. And then the last bullet point here about changes we're going to talk about is illegal discrimination. And we're actually going to come back to that one in a moment, but I suspect everybody on the call recognizes that there has been a tremendous uptick in discrimination and bias claims throughout real estate transactions, the lending process, and the like. That's probably the #1 issue that we're seeing. I can tell you, between real estate brokers and appraisers at the moment, and between whether it's Cook County, Chicago Commission on Human Rights, Cook County Human Rights Commission, Illinois Human Rights Commission, various other states, HUD, we're in 6 or 7 states right now with active discrimination complaints as a result of something in the transaction or in the loan process. So that's a big item at the moment, and various layers of governmental authority are looking to fix that. There's language pending in Washington right now about new federal standards in lending and in valuation to try to address bias. On the state level, there's been some additional movement as well, and we'll circle back to that in a minute. I'm going to quickly bounce through an idea with license renewals. This doesn't directly apply to real estate brokers or mortgage loan originators. It has squarely landed on the real estate appraisers, and so we don't know how this is going to net out yet. The department took it upon themselves to go through some large IT update for all of their database system, and it absolutely tanked the licensing and testing component of all of this, right squarely in the middle of renewal cycle for real estate appraisers. Also for a number of other professions. Accountants are among them, and also in all, probably 15 or 20 professions got impacted because they're all in a renewal cycle right now. Every single one of them, besides the real estate appraisers, have all had their renewals that were supposed to be due in August or September, all get punted out to December 31st, at which point the department thinks they'll have the IT problem solved. The real estate appraisers have a particular problem in that they're on a federal licensing, federal oversight concern. So they can't continue there. So every real estate appraiser has had to physically print out a copy of a paper application, fill it out, and mail it into the department, which means buckets of mail are getting dropped on the department daily in the lead up to the September 30th renewal date for real estate appraiser licensing. It's a complete nightmare. Now, for most of the folks on this call, you renewed earlier this year. The technology worked fine. There's going to be some stuff. I mean, community association management, if you're doing condo boards management stuff and all that, that was set to go in August. That seems to have come out without a hitch. But going forward, the home inspectors are supposed to renew by December 31st of this year. We don't know for sure yet if they're going to be able to get back into the electronic process or if they're going to get rolled onto paper. And quite frankly, we don't know yet if the department is actually going to meet its own suggested deadline of later this fall to have the system online. So we bring this idea of snail mail up to warn you that it's a problem. It's a problem they know about, and we don't have it fixed yet. Would they allow licenses to extend through another date before there's renewal? Maybe, because they really don't want to get the physical mail copy of this. But sometimes that's not always an ability. So beware that something's going on within the department right now. The other thing, which should have impacted everybody already for the renewal, is there is an additional 1-hour sexual harassment prevention course that everybody must take as a part of their renewal education. And so keep that in mind. And if you haven't, it could subject you to one of those citations or a ding against your license, or potentially an inability to renew if you're not on top of that. So that's something else, again, just to be aware of.
And
Go ahead, Charlie.
And it's in addition to your ordinary CE. You have to have that. So if you were 28 hours that you required, you now have 29 hours.
Yeah, we had to do it too in our for mortgage licensees.
Yeah, it's all professions at this point. I mean, frankly, we have to do it as well. So that's something that we've also done within the office here, is we've set something up because that covers all professions at this point. IDFPR has said that so long as it is a course that is an approved course by IDFPR, they don't care if it's being offered by that accounting firm over there, but it's a department approved course. It will count for your real estate broker license or your MLO license. It doesn't have to be solely from an education provider specific to your profession. You just have to get it from a course that the department approved. So we do know a lot of folks have been bouncing around to get it even from another course provider from another profession because the course itself met the requirements and was approved. It's sort of a universal course at that point.
And you have to do it every year.
Yes, that's a Department of Labor issue. You have to actually do it every year. So moving on with there's legislation pending and forthcoming about discrimination. House Bill 93 was introduced in the Illinois State House by Representative Mary Flowers, and this was bill language that directly impacts both the Real Estate License Act and the Real Estate Appraiser Licensing Act. And this also goes to valuation again. Now, it got through the House, it made it to the Senate, it got assigned to committee, and then it basically withered on the vine in committee. So this is not the law of the land, but there's no reason to think this won't get reintroduced again in the spring when the legislature goes back into session again to take up new items. And this would specifically change the language of both license laws. And in essence, for the purpose of for real estate brokers, brokers who also perform broker price opinions or comparative market analyses may be subject to whatever this new language addresses. That's what it was keyed in on. It was for appraisals, BPOs, and CMAs, and it was going to address both license laws about the fact that various protected classifications cannot be considered, and the impact of being a member of one of those classifications cannot be used as a determinant factor in valuation. Putting it in layman's terms, you can't consider somebody's race when you're trying to figure out how much their property's worth. That seems fairly obvious, you might think. However, depending upon the language used, and I can tell you from having done this in appraisal cases previously, it's not always as cut and dry as it might sound. You say, I would never consider somebody's race when I'm assigning a value to their home. Okay, great. The home is located in this neighborhood. The predominant characteristics of their neighborhood are X, Y, and Z. Oh, why didn't you consider this other sale that was in this other neighborhood? Well, the subject is located in a neighborhood because of its characteristics that's inferior to the other. Oh boy, have we crossed a line or haven't we? That's where the gray area is. So this is a bit of an odd legislative push because it's telling you that it's illegal to do something that's already been illegal, okay? That part makes it a little bit strange, but that lets you know that there is a very serious concern about the use of, right now, traditionally, it seems like the cases we're seeing are about racial bias and racial discrimination, but I don't for a second believe it's going to be simply that. I think it's going to be sexual orientation and marital status, familial status, and the like. Really anything that falls under a protected classification as enumerated by state and federal governments, those really are not intended to be considerations in the value process. So if you're doing a BPO for someone, then my goodness, if you're going to go ahead and say, here's other sales in the area, and just so you know, this one isn't going to be worth that because this is the residents are actually of this race. I mean, I'd like to think nobody's doing that, and I'm not sure how good. I'd like to think Charlie and I are pretty good, but I'm not sure how good of a job we can do helping you if you're putting things like that in your report. But it's not always that cut and dry. Sometimes it's what people might think an innocent statement that I've been putting in for years. For example, the subject neighborhood is inferior to the neighborhood where this other sale exists. Well, what does that mean to the reader who might not have your background and understand what that means? I mean, maybe that's because of the school district. Maybe that's because of the width of the street and traffic counts. We don't know what that characteristic is. If you just make a subjective statement that it's inferior, you're going to run up against a problem of how that's being interpreted. And so Charlie sort of compiled a list here of what we're talking about when we talk about what's bias and what are we looking at subjective versus objective. Go ahead, Charlie.
I was going to say, with
Hey
the
guys,
Yeah.
I wanted to kind of break. We started getting some questions in.
Great.
So I wanted to make sure we got that. I think, this piece as it relates to, potential discrimination for doing a BPO, I've not heard any chatter about that. So maybe the agents have, but I mean, it's pretty, what you're talking about on the appraisal and the BPO side is pretty frightening in the sense that, now, like you said, when I read appraisals, I see, inferior this. I mean, there's all kinds of comments just relative to the comparison of the sales. Now, the question would be, would you have to go even farther? But that's not the questions from the registrants, but, I think it's pretty interesting as what's potentially coming. All right, so I'm going to read this question because I'm not quite sure I understand it. So I'm hoping that the person, yeah, I'm starting here because maybe they can clarify this a little bit. So the question came in, excuse me, if a realtor does one very small unit job of property management, so I don't know if they're saying a portion of property management, is their professional liability adequate for this? So I don't know if they're trying to say, hey, I have professional liability and I'm only doing a small portion of property management. Maybe I don't have to get licensed. I don't know that I can fully understand the question. So I'm going to hopefully they'll update that. So we're going to jump to the next question. If not, we could try to come back to that. But
Sure.
I don't know, unless it makes sense to you guys. I think I need a little clarification.
I might actually be able to touch on that one. If there is a clarification coming, I certainly want to see it. But one of the things, we counsel a lot of different real estate brokerages. And one of the things that's most common is that usually the errors and omissions policy that's in place for that brokerage covers real estate activity, brokerage activity. So that's going to be listings and transactions and holding earnest money and the like. Frequently, however, property management, collecting rents and those sorts of things is not contemplated under that errors and omissions policy. So even if you're only doing so for just one unit, your policy may not cover if you make a mistake and something goes wrong with the one unit you're managing, that may not be covered under your errors and omissions policy. One of the things I think Charlie and I have frequently preached across all of our professions is really sit down with your policy, read it, and make sure you understand what you're covered for and what you're not covered for. And when in doubt, you need to be in communication with your broker who's selling you the policy. And I always tell people, when I say you need to know who your broker is, I'm not going to tell you need to actually know the names of each of their children, but you probably better know how many children they have. Because if you're conversing on that level, that means that you're probably discussing the sorts of information about your business that they need to know so they can best guide you to the coverages that you need. If you're an appraiser and you're doing appraisals and now I'm going to do BPOs or evaluations, well, guess what? It's not covered under your E&O policy unless you have additional coverages. If you're a broker and you're doing BPOs, but now you're going to do evaluations, it's different thing. You're not covered under your E&O policy unless you've added that on. If you're doing broker activity and you don't have property management also added onto your policy, don't assume that that's automatically covered and comes with it. Frequently, it doesn't. So I expect that might be where the question was. But obviously, if there's further clarification that comes in, I'd love to hear about it.
Yeah, that came from Paul. So Paul, if that answered your question, great. If not, shoot us a little bit of a follow-up. Next question we have is, this is kind of interesting, and maybe certainly, Craig, if you were still sitting on the IDPFR, you could speak to this. But I think there's a better part of it where this person was trying to get to it. I'm sorry, my questions are moving a little bit. So the question that came in is, how do we outlaw love letters like some other states have already done? And love letters being, if you gentlemen aren't 100% familiar with it, it's the letter that the buyer writes that says, my kids love the backyard, Susie's going to love the bedroom. And it's that letter because we're in a highly competitive market where we've seen the letters come to the sellers, encouraged most likely by the selling agent, because the selling agent is saying, hey, I've heard this will help. It helped me on a couple of the transactions, and you send it in along with the offer and the pre-approval letter. Now, I know that NAR has commented and basically stated they don't endorse them. They think potentially there's some discrimination that could be leveled right there, as you have a single buyer versus a family, and you chose the family versus the single buyer because Susie likes the bedroom upstairs. So I'll let you guys kind of speak to that a little bit, what your thoughts are. And I think the one thing that I'd like to hear as far as an answer is just, as an agent, if you don't want to be involved on that either side, how do you just say no to the client that, we're not going to do a love letter and this is why?
So I think there's two layers to that. Rich, you're exactly right. NAR has already made statements on that. And so you realize that's sort of executive fiat coming down from on high. That's going to pass through Illinois realtors, and whether your car or Moore or North Shore Barrington or whatever otherwise your local association is, that's going to trickle down through. I expect that we're actually going to begin seeing association related ethics concerns about all of that. I think we're going to see those sorts of grievances come in. I do anticipate IDFPR is going to take some sort of a position on that going forward. For the agents out there that have concerns and wonder how to express that, honestly, I would encourage you to reach out directly to IDFPR's real estate division. And if you're trying to get a hold of the real estate director's office over there, Lori Murphy, you're going to end up probably not getting to Lori. You'll get to a staffer. But I make your voice heard on that. If you think there's a problem with these and you think that the state should be doing something, that's actually the sort of feedback that they want, because it helps them then shape the sorts of things that might go forward, and make it known within your local area associations as well, because a lot of these local area boards and associations also have people on the state board, and the state board folks are the ones who are ultimately going to be working on making the rules. So I would encourage people to raise their concerns on this, because frankly, it is a problem.
Yeah.
And it has become a very common item over the last couple of years in this superheated market, that people are dropping these little love letters in hopes of swaying the seller of why I'm the more, I'm the more Saturday Evening Post idealistic painted family on the cover. And there's problems with that.
Right. And it sort of goes again to the point of bias and undue influence.
Right.
And it's something to be dealt with. And, Craig alluded before that, subjective being bias and objective being not bias, objective being factual. And, as opposed to your personal belief or your personal opinion, which leads to the bias issues. I mean, one of the things you have to sort of remember with these things is, if you, with the bias, with all these things is articulating facts, statistics, as opposed to conclusions. A high crime neighborhood, what does that mean? It's, poor schools or things like that, as opposed to, giving the statistics or giving the facts as far as what happens. There are, the amount of police presence or something. It's those words. The words have and phrases matter, and that's what the department. That's what these all are going to be looking at. So the impact is that, well, who makes these complaints, and who is who's complaining that somebody else got the property instead of them. And basically that talks about the impact of the bias is the disgruntled. And who are the disgruntled? It can be someone who didn't get the property. It can be someone who didn't get the loan. It can be somebody who considered that a victim of undervaluation, so they don't qualify, or overvaluation, all those things. It's disappointed expectations that you have it. The positive thing that comes out of, I think, the redundancy of all the regulation that we have with bias, and bias has always been, discrimination has always been banned. If you look at the Real Estate Act of 2000, you couldn't discriminate 20 years ago when they enacted the act. You still theoretically can't, but because of the world that we're in, there's some redundancy, and they're doing it. The positive is that you have this unbiased analysis of property being what it is, being what it's presented as, so that you can make an informed decision and not be swayed by somebody's opinion necessarily, or somebody's conclusion about it. They want you to make the decision, you weighing the facts to come to the reason why you did. They want it predictable. So
hey Charlie,
yes.
I want to put one little short follow up on the buyer's letters.
Yeah.
John wrote a big response here, but I want to kind of cut to the point that I think that it is, I'm going to take a little excerpt out of it and ask you guys your opinion on it. It says, I've seen these letters and have yet to feel that any of these buyers are trying to put themselves in a preferred spot because they belong to a racial, social, economic, cultural, etc. group, but as a tool to get the seller's attention to set their offer apart. Now, he went on to say that I'm going to discourage any user clients from using this tool. But, the challenge I think you have, even if you don't see anything in those letters and you give those letters to the seller and the seller makes a decision, there could be something that made a decision, again, single parent versus a family. I mean, any decision that they can make that would cross those lines. And again, you just turn that power over to the seller anyway. Any decision they make that can cross those lines, I think can get you in trouble. And gentlemen, if you want to comment about that,
it's sort of like, again, it's sort of like telling jokes on the internet. It's, through email. You can't, email doesn't give you, the emphasis of particular words or anything like that. That's why you use all caps or all bows, but it doesn't have a sense of humor. And so, and it's something that when Craig and I, when we have to present people for depositions, there's a court reporter there and the lawyers may make snide comments or may joke, but we always tell our clients, say nothing, during the breaks, whatever it is, or even don't be facetious, don't be snide, don't be glib, because when it comes to when the transcript is done, and that's what you see, you don't, they're typically not videoed. They answer a question, did you do that? And you answer, yeah, sure, meaning no, or something. It comes off as yes, sure, which is different in tone, different in meaning. And so, it's all those things, and that's where when people are looking at these letters, and that's something that we will go through down, Craig put up the screen now, solutions. When there's one, the next page is record keeping. It's your file. What's in there? What supports what you've done? How do you justify the position that you've taken? By and large, and something we talked about earlier was that, the IDFPR at least acknowledges mistakes. Mistakes happen. Can you support, though, what you did? Can you show what they did? And the easiest way to think about it, frankly, in my mind, is we all went to 10th grade. We all took geometry. At least I think most of us took, all of us probably took, that's a conclusion I'm going to make. We all took geometry. And the first proof that we had in geometry was that opposite angles were equal. Remember, there were two intersecting lines and you had to prove one was equal to the other. Well, how did you do that? That's what the IDFPR wants you to explain, and you explain it, and if you give like one angle, they always said this angle is 30 degrees. How do you explain that the angle opposite is 30 degrees? And well, the lines are 180. And that means that the other angle next to the 30 degree is 150, which means, and you go through that process. They want that logical. The fact that you come up with a wrong answer, as long as you can explain the steps that you took, that's the important thing. So again,
Charlie, you lost all the people that hate math. Yeah, everybody who didn't take geometry or hate it, they're all just out. So,
which is fair, because let's be clear,
I'm a math guy. So
if we were better at math, do you think we would be lawyers? I mean, let's be very clear about where this has led us.
That's true. To everyone, I apologize. Sorry.
That's okay.
But in that, and Charlie is correct. I mean, it's very much a matter of sort of show your work. I mean, a commonly heard refrain through the department hallways is even a broken clock is right twice a day. In many ways, the department really doesn't care that you got the right answer. And in their context, that actually makes that sort of an ineffective defense. Well, but I came up with the right answer. Well, if you did all of the right things and or if you did all of the wrong things and tripped and fell into the right answer, that doesn't make them sleep any easier at night. They're still worried that you're going to continue to do all of the wrong things. You're just not going to be lucky enough to stumble into the correct answer each time. That's where their primary focus is. And so your best tool to protect yourself is in showing your work and preserving the steps you took. This is how you address a concern about bias or discrimination. But frankly, this is just how you address a concern about general competency. Are you preserving your records? And does that record show that you did the things you were supposed to do in arriving at whatever your outcome was. And if you can do that, vastly more often than not, you're going to end up walking out of a circumstance better off. Going back to the love letter concept, the point that was made by the viewer is exactly right. Maybe the buyer has no intent whatsoever to place themselves in a separate socioeconomic status or familial status, whatever the case may be. Just how do I set myself apart from this morass of other offers coming in? But now they get the property. Somebody else didn't get the property. And that person is a member of a protected class. And they go, I just know for a fact the reason I didn't get this house is because of XYZ characteristic. I'm filing a complaint with the state of Illinois. I'm filing a complaint with HUD. The next thing you know, that licensed real estate agent's getting dragged in there going, well, did you transmit all of these characteristics about the other buyers? And did you direct your seller did you influence them to sell to one person and not another? Because of course not, I would never do that. Well, okay, here's a letter. And somebody's complaining saying, because I'm something else, that's why I didn't get this. You might be 100% vindicated at the end of a very long and very expensive process. And that's, if you can avoid ever getting swept into the process to begin with, you're going to be far better off. But you can't avoid that all the time. Some things may come up that are just going to drag you in. The way to protect yourself is to keep those copious records, contemporaneous records and notes. If you've got fully executed documents between the parties, whether it's something that they're agreeing to, whether it's something where they're waiving this liability or they're waiving that claim, you'd better have a copy of that in your file. You'd better not have blanks on anything and leave it up to interpretation later. That's a problem. If you get waivers or acknowledgments of things, get it and preserve it. And I tell you, this last bullet point on the record keeping idea is exactly what I'm doing right now to defend a real estate agent who's been brought up on charges that he refused to rent a unit to a particular potential tenant because of race. Thank God this guy saved all texts, all emails, has all the call logs from each communication with this potential tenant and with other tenants, and all of that's in the record. We've been able to take that material and provide it to the housing discrimination authorities for them to vet. This is what's going to save that person's bacon, is they've got all of their attempted communications with the person. Because the story right now is basically, oh, well, he ignored me because of my race and refused to rent this place to me. Well, we have a litany of emails and missed calls and all the other stuff that shows, no, here's somebody that was trying really hard. And, I'm sorry, frustrated expectations. It didn't come together, but it wasn't because there was a willful ignoring, or it wasn't because somebody was actively discriminating. That's the key to the city on all of this stuff is, if people can tighten up their record keeping practices, it's going to go a long way towards helping them. Doesn't matter how good Charlie and I are, we're even better when the records are well kept. That's it. That's the magic in our sauce right there, is your records are directly determinant of how good we are.
Guys, we're getting close to the 1 o'clock hour. And I think you covered a bunch of great points. I mean, just the record keeping alone, the making sure the IDFPR has the correct email address, kind of talking about this whole love letter thing. Is there any, with a minute or two left, and of course I open it up to anybody else to fire their question here, ultimately, I don't want to say this too loud. Panelists, cover your ears. Not being charged $250 an hour for this legal advice. So get your question in the chat. And with that being said, and I don't even know if that's what they charge. We're not even going to talk about that. But that being said, gentlemen, you guys really crushed it today. Is there any other points that you want to make to the licensees that are here on the call?
Yeah, when a lot of when a lot of them, when you get the nasty gram, your stomach drops to the floor, talk to somebody about it. Get some help. Don't sit and and think that you're going to take care of it, and don't necessarily believe, oh, it's nothing, I'll just put it in my drawer and wait. No good will come from that. Get help, whether you call Craig or you call me or you call your insurance broker, whatever, talk to somebody and get help, reach out. And inevitably, if if they know what they're doing, they should be able to help you.
It's
Charlie,
huge.
do you guys have a contact slide? And if not, I'll see if Tony can get the information in there.
Our first, I think the initial slide itself had our contact information.
Correct. Yep. Slide
Yeah, if
one
you guys
had
put that, sorry about that, Craig. And if you guys if you need this, certainly feel free to reach out for me or Tony will get you some contact information. But yeah, there we go. So that's the firm if you guys need it. And yeah, I mean, God forbid you get that notification. This is certainly the way to, this should be after your broker, who may have probably got the notification at the same time. This is probably your next phone call.
No, that's absolutely, and to echo Charlie's point, call your insurer, call your local area association. If you call CAR, if you call Moore, they're probably going to tell you to call us anyway, because they know us. We work on this stuff. Call your insurer. They might send, hey, you need to talk to these guys because we've worked with them too and all of this stuff. But reach out and get help is absolutely the right answer on all that. And Rich, from my end, I know we kind of run up against the clock here. Thank you very much. Appreciate the opportunity. Really glad to be here.
Absolutely. Thank you guys for coming out. Great information, and thanks everybody for attending. And Charlie, I'll see you next month. And Craig, thank you very much, guys. So have a good one, everybody.
Thank you.
Fantastic. Thank you.
Thank you. Thank you.
Thanks, guys. Bye-bye.